Good afternoon, everybody. Apologies for the static picture of myself. Somehow Zoom has failed us again today. On that sense that I'm not showing, but at least Lise and Phil are showing. And so welcome. This is our third webinar in a series that we've been covering on topics relating to sustainability, business and human rights, and modern slavery issues. I am Colleen Theron. I'm the founder of Ardea International. I'm a lawyer, and I am so pleased today to be able to welcome Lise and Phil Bloomer. I'll speak or introduce them to you shortly. Just for those of you that aren't aware of who we are, Ardea International is a specialist sustainability, business and human rights consultancy with expertise in modern slavery. We work across sectors, and we work with small organizations, NGOs, and companies ranging from mid-sized to FTSE 100 companies. And as I said, it's my real pleasure today to have Lise Smity and Phil Bloomer join us, both eminent names in the space around business and human rights. I'm sure that you would have come across them before. Phil Bloomer is the Executive Director of the Business and Human Rights Resource Center, which tracks human rights performance of over 7,000 companies across the world. It seeks accountability for allegations of abuse and empowers human rights advocates in business, government, and civil society. And Phil was previously the Director of Campaigns and Policy at Oxfam, where he led the global campaigns on climate justice, trade, and investment for development, access to medicines, universal primary education, and major humanitarian crises. So it was a real privilege to me that Phil, when was asked to participate in this, agreed. And equally, Lise Smity, who is a fellow South African and is the Senior Research Fellow in Business and Human Rights. She joined BIICL in March 2015 and conducts research on corporate human rights due diligence and other aspects of implementation on the UNGPs. And prior to the Institute, she was a practicing advocate at the Cape Town Bar in South Africa. She has an LLM in human rights from the University of Stellenbosch, the same institute where I did my BIICL, and a master's in international law and economics, the World Trade Institute in Bern, Switzerland. And what Lise hasn't mentioned is that she is one of the major authors of the EU Commission report, which I think she's going to discuss today, and which I believe was quite instrumental in the EU really taking a look at mandatory due diligence and what should be done about it. So I think if I can just now hand over to Phil. Phil, if you are able to take over the screen, and we look forward to hearing from you for the next 10 minutes or so.
Great. Am I on the screen? There. Is that okay?
I can see you, but we don't have your screen sharing. I can stop sharing if you can take over the screen share.
Screen share.
At the bottom is a green button.
Well, do you have slides or?
No slides.
Oh, okay. Then don't worry. Then we'll just pin you.
Ah, good.
All right.
Is that okay?
Yeah, absolutely.
Am I all right now?
All right now.
Great. So first of all, very big thanks to Colleen and to Ardea for this opportunity to talk about the mandatory human rights and environmental due diligence, and especially to work and talk alongside Lise, who's done so much to really persuade some of the key opinion formers and decision makers to move on this issue. I think the first thing I wanted to say was just, mandatory human rights and environmental due diligence. It's really, what should be embedded in every company's practice, policy, and performance, because it's just about identifying the salient risks in the operations and the supply chains, and then taking the actions that are necessary to prevent and mitigate those risks. So there's not a lot of mystique around it. There's just not been a lot of progress around it over the last decade. And so the trends there have been, the UN guiding principles and the OECD guidelines have stressed very heavily this issue of due diligence. Of course, the guiding principles spoke about a smart mix back in 2011, a smart mix of voluntary and regulatory action and business incentives. But of course, if you look at the national action plans that have been developed, and they're relatively few, about 25 out of the 180 or so countries in the world, even in those national action plans, there is a huge emphasis on voluntary, as John Ruggie has pointed out, a huge emphasis on voluntary and very little on the mandatory regulatory side. After some period of frustration after 2011, some countries started to introduce mandatory transparency, that idea of the nudge politics, that somehow by asking companies to say what they have done to mitigate the human rights risks, that would be enough. And of course, unfortunately, the progress from there with that technique and that tool has been glacial again. And so that's why I think now we have this much bolder move by a good number of governments, encouraged by parliamentarians, encouraged by investors, responsible companies and civil society, to really move towards this mandatory human rights and environmental due diligence. And that's, I think, given enormously greater emphasis because we are living in this period of convergent crises, the convergent crises of unsustainable inequality in markets, the inequality of power and wealth that is now seen as unable to continue, and also obviously the crisis of ecological breakdown, and the accompanying crisis around governance, the multilateral system being very heavily under strain, but also at the national level, governments being unwilling or unable to take the moves necessary to embed in national law the values that the populations espouse. And so that collapse of public trust in global markets, which Edelman's Trust Barometer has shown year after year, which says that essentially you're not living in a golden age of globalization, but the public relates global markets back to rootless corporations, unsustainable inequality, ecological crisis, precarious employment, stagnant wages. These are the things that are also driving this enormously in various jurisdictions. So, and right now, of course, the pandemic has come on top of those twin or those three crises together, and the pandemic has exposed and exacerbated many of the inequalities that exist in markets, but particularly in the global supply chains, as we've seen in Bangladesh and Cambodia and Myanmar and so many other places, where the workers at the bottom of supply chains, and indeed, lest we think it's just over there in Leicester in the UK, but the way in which those global supply chains have immediately transferred the risks and the costs of the disruption of the pandemic down to the weakest and most vulnerable parts of that supply chain, which of course are the workers. So it's because of those things that again, this has been given an extra push in terms of developing a genuine smart mix, as John Ruggie has described it. So it's because of that we're now in this situation of moving from voluntary and nudge or mandatory transparency into that mandatory human rights and environmental due diligence. Lest anybody think that I'm just making it up, in terms of the performance of companies, you know, we, along with Aviva and APG and Nordea Bank, run a benchmark called the Corporate Human Rights Benchmark, where we essentially assess and rank 200 and so of the largest companies in the sectors with the highest human rights risks. Now, in the last iteration of that, in November 2019, half of those companies in those high-risk sectors scored 0 on every single human rights due diligence indicator. Every single one, they scored 0. If you take a more, if you then focus in, for instance, on some of the most egregious aspects where you'd expect due diligence to be really being looked after, such as modern slavery, forced labour, there we've got a benchmark called Know the Chain, where the average score of the companies in that is 20%. That's across 3 of the highest risk sectors again. Germany today, a new report out from Germany assessing the companies that are being measured there for their human rights due diligence. 22% of them met the due diligence requirements, and therefore that should now trigger a German law for mandatory human rights due diligence. And of course, lest we forget, Germany has the presidency of the European Union over this next 6 months. Nevertheless, despite all that bad news, I'm a harbinger of good news and optimism as well, in the sense that there are really in each of those benchmarks, there are leading companies which demonstrate the far better practice, that demonstrate that due diligence is both commercially viable as well as a moral imperative. So I think now companies have to really anticipate legislation and regulation. You've had it already in France with the Loi de Vigilance. The EU Commissioner Reinders has come out, and Lise will speak to this in far greater detail on the human rights, environmental due diligence and governance legislation. We've got Germany, as I say, probably being triggered to issue a human rights due diligence law. We've got the Dutch already speaking about their child labour due diligence law becoming more generalised. And we've also got investors speaking out strongly now for this kind of legislation, socially responsible, but even some of the mainstream as well. The Investor Alliance for Human Rights, which is valued at manages $3 trillion worth of money, came out very much in favour of the mandatory human rights due diligence, linking it essentially to this fundamental challenge of the purpose of the corporation. And again, the leading companies, there's over 1,000 in Europe that have already signed up saying that they believe that this is fundamentally important in terms of providing them with, in terms of ending the impunity of irresponsible competitors who will gladly externalize risk, in terms of providing legal certainty on an enhanced purpose of the corporation, and a sense that they have nothing to fear, and in fact much to gain from the change, provocation and a catalysis of a changed culture inside the organization. So finally, I'll just say a few words on what we have learned about some of the best practice. Because again, from our perspective, most companies have nothing to fear in terms of this legislation. Sorry, not most companies. The leading companies have nothing to fear. The vast majority of companies have got a shed load of work to do. So if you look at the best performers in terms of the human rights benchmark and look at what they're doing in terms of due diligence, you'll see, first of all, they are embedding a culture of responsibility from the top of the organization, that they want to end abuse, that they are open and willing to learn about risks and identify them and address them with stakeholders. What does that therefore mean? It means, first of all, that there is clear assigned responsibility on human rights due diligence and human rights and environmental risks broadly inside the organization. Not the usual, well, we have a team that works on this. Who is it who is finally responsible for this in the company? Secondly, there's a major emphasis on transparency, public disclosure. But public disclosure in a way which is relevant to the stakeholders who need this information to be able to assess and support the risk, to support action, to identify risk and mitigate it. It's workers, it's communities, it's suppliers that know where these risks are, far, far better than any brand does, for instance. So you've got to empower stakeholders to help you. And some of the companies are doing precisely that, Samsung, Adidas, etc. Next, the identification of salient risks, the assessment and prevention around those risks, but then also going that extra mile and reporting on the outcomes of the preventive action that's been taken in the operations, in their gig platforms, and in their use of gig platforms and in their global supply chains. Next, many of them really work with those stakeholders. You've heard about a lot of good, fine words have been spoken over the last year about the importance of moving towards stakeholders and not just the primacy of shareholders. But if you look at the actions that are being reported, we need a transformation in the approach to stakeholders, suppliers, workers, communities, understanding their reasonable expectations from the company, engaging, listening, researching, selecting the areas to work on. Grievance mechanisms are fundamentally important to due diligence because they enable a company to identify risk, but that's also critical in terms of protecting human rights defenders. Many companies have, we are seeing a really worrying spike in attacks to silence human rights defenders that are simply trying to expose irresponsible investment and irresponsible business action. They are the canaries in the coal mine for many for companies. So we've got to protect those people, not try to silence them. And finally, that issue of collective research and advocacy. Most of the risks that big corporations run are not singular to that company. They are to do with their suppliers, and their own purchase and leverage on one supplier can be very small, precisely because that supplier's got lots and lots of customers. So that collective action of sending a single message about the zero tolerance of abuse is fundamentally important. You can only do that if you've also got collective research. So I think that's where we are at the moment. The majority of companies are reporting lots of data, but most of it is not powerful or relevant to human rights due diligence and to making change happen. The worst case of that, I think, unfortunately, I have to say this, is social audits. The majority of compliance statements from a $60 billion industry are, at best euphemisms and at worst fictions. And so it's things like that where we're seeing vast amounts of money being spent, huge efforts being made, which aren't actually delivering the change that's required. But from now on, and you'll hear this from Lise, everybody must now expect and prepare for regulation, legislation that will demand responsibility. And that's all that workers and communities at the bottom of these supply chains should expect from companies in their communities and in their countries. I'll end there and go straight over to Lise.
Thank you so much, Phil. That was really useful and very succinct, very clear, and hope to build on a few of those points that you've made, as I'm sure Lise will now. So just hand over to Lise. Are you okay with your screen share? Lise, you just have to unmute on the bottom left. There you go.
Can you hear me now, Colleen?
Yeah.
Okay. Sorry, I am just going to turn this into a slideshow. Okay, great. If you can see. I hope that works. Great. So I'm just going to present the findings from our recent study, which we undertook for the European Commission on due diligence requirements through the supply chain. I see on the participants list there are a number of people who would have already seen this presentation before and are very familiar with the study. So just as a background, we know what human rights due diligence is. It's a concept originally from the UN Guiding Principles on Business Human Rights. And it has that ongoing nature, the assessing, integrating the findings and tracking the effectiveness, and then also communicating on how impacts are addressed. And this is just important to remember this for the purposes of thinking about what the law might look like. So we undertook a study last year for GG Justice and Consumers, and we BIICL led this with Civic Consulting and LSE Consulting. there were several co-authors on the team, and then it was published on the 24th of February this year, and then on the 29th of April, Commissioner Reinders announced that there would be a legislative initiative based on the findings of the study. So that will not take place, but obviously the exact parameters of the law is not yet known and will be hopefully clarified in due course. So the study is very large, and so I thought it might help to just run through the different components as a sort of a brief overview. The first component was the market practices section, and for that we undertook empirical research. We had a really overwhelming response, perhaps as a result of the importance of the topic to stakeholders across the spectrum. We had 631 survey respondents, of which 334 were from individual companies, and 297 were the general survey respondents, which included civil society, industry organizations, trade unions, government officials, legal experts, etc. Then we undertook 50 interviews and informational calls. Both the surveys and the interviews were anonymous, and then we also had 10 company case studies, which were the only part of the market practices section where we named the companies, because the case studies were based on public information rather than the interview or survey data. Then we also had the second section was the regulatory review, where we looked at the existing examples of due diligence, the origins of due diligence and the guiding principles, and the expansion of our due diligence into OECD guidelines. We had 12 country reports authored by experts, and which of which the findings were incorporated into the regulatory review section. And then the third section was the problem analysis and the regulatory options, where we identify the regulatory options and sub-options, which we will discuss shortly. And then the task 4 was the assessment of the options. This was sort of a preliminary impact assessment. This was undertaken by LSE Consulting, which are economists based at the London School of Economics, and it looked at, on a very preliminary level, the potential costs and benefits of the different options and sub-options, but also the implications for enforcement and the social, human rights and environmental impacts which could be expected. This last section, it was just preliminary, because the regulatory process will also have to entail a sort of a fuller impact assessment. This it is very difficult to do an impact assessment based on very, very vaguely described legal options. So our 4 main regulatory options were, first of all, the no policy change. That's the one that one always has to have if you want to do an impact assessment. On that, as we will shortly see, the stakeholders felt that this would not be the preferred option, for the EU not to take any action. There's already developments taking place at member state level and elsewhere in the world, and one of the key themes was the fragmentation that this actually would potentially lead to. So the idea that would not be the preferred option. Option 2 was new voluntary guidelines. Again, the feedback was that there's already so much voluntary guidance, including the UN guiding principles and various industry guidances, etc. So that was not the chosen option either. Option 3 was new regulation requiring due diligence reporting. So that would be distinguished from the existing EU non-financial reporting directive. We distinguished it in the sense that it would follow more closely the wording of the UN guiding principles and be more focused on the actually the risks to the rights holders, whereas the EU non-financial reporting directive still has quite a lot of focus on materiality. And then the option 4 was really the one that everyone was interested in terms of the mandate. So that was mandatory due diligence as a legal duty of care or a legal standard of care, and there that ended up being actually the preferred option. these different sub-options which were identified there was firstly just a new duty applying to a narrow category of business, so limited by the sector, the sector-specific approach, which we have seen already at EU level and a few other examples, although it's slightly different from this. And then the regulation which applies across sectors, but limited, first of all, to only large companies, so similar to what we've seen in the French duty vigilance law. Then the second sub-option there, which applies to all business, including SMEs. And then the third sub-option there, sub-option, is a general duty which applies to all companies, regardless of size, plus an additional obligation that would apply to the large companies. Only the example that we used there was just, I mean, this is one example of how this combination approach could be used, but it could be a general duty applying to all business, and then there's specific target setting, with the climate change target setting and reporting duties applicable to large companies. But that's just one example, and it could take any form. And then sub-option 3 was just looking at the enforcement. So the idea that it's mandatory, it has to have some sort of consequence if there's nothing, if there's no due diligence. So we divided that up into mechanisms for judicial remedies, really, and then also state-based oversight bodies and sanctions for non-compliance, so the sort of more regulatory or administrative oversight by the state. We did those two options separately, even though we also noted that you can have both in the same statutory instrument. It's just, hi Colleen, I seen your back. It's just that we discussed it separately because they have different cost implications and potential impacts, other impacts. Right, so let's see if it still goes. So the key categories from the market practices section really was just that just over 1/3 of business respondents currently undertake human rights due diligence, which due diligence takes into account all human rights and environmental impacts. In that sense, very similar to the findings from the German survey and the CHRB, which Phil just mentioned. The majority of this, however, is focused on the first tier of the supply chain only. Then, as we'll see shortly from the stats, there was a general dissatisfaction with the current legal landscape. There's a preference for a cross-sectoral standard which takes into account the specificities of the operating context. This is again echoing the description of due diligence in the UN guiding principles. And then it came across in the survey and in the interviews. The participants mentioned the UNGPs and the importance of the concept of human rights due diligence in the UNGPs, and the fact that this should not be abandoned for a vaguer standard, and the importance of keeping to that context-specific and very influential standard. Just a few stats which I thought were interesting. We asked about what are the main incentives for undertaking human rights due diligence, or what are or will become. And it was really interesting here to see that if you look at the blue, which is business, and the orange, which is industry organizations, the top risk for both business and industry were reputational risks, followed by investors requiring a high standard and consumers requiring a high standard, which both again are linked to reputational risks. So we thought that that's interesting because in the way that the question was phrased, if you look at the legal ones are actually at the bottom as far as business and industry are concerned. The regulation which allows for judicial oversight, risk of litigation, and regulation which allows for sanctions or fines, standards required for export credit. Those are the legal ones that were scored the lowest by business, but actually scored the highest for civil society. And so there was an inverse relationship here. We try to explain this by the fact that currently the regulation that we have seen to date, as Phil has mentioned, is focused quite a lot on the reporting requirements, the transparency, and that is tied to reputational risk. They don't really qualify as substantive laws requiring due diligence, and so therefore the idea that there's a reputational risk ties to that. It's also that's what the nudge theory, I suppose, is based on, and it's also reflected in a way in this graph. Then the criteria which the EU uses for its legislation is whether it's effective, efficient, and coherent. And we see here that this just ties in with the point about the general dissatisfaction with the current landscape, is that the majority of respondents disagree that current laws are effective, efficient, and coherent. And that's in both the business and general stakeholder survey. Again, there's a disagreement, which is the orange, about whether there's legal certainty in the current legal landscape. And then this is interesting just findings, I think, about the benefits for business. So which are the benefits which would accrue if there was a general mandatory due diligence law at EU level. The single harmonized standard was one of them. Leveling the playing field is one of the ones we've heard of most often, I would say. The idea of providing legal certainty also throughout the supply chain, and then facilitating leverage with third parties by setting a non-negotiable standard. And that also ties in with the collective power of an EU legislation. I think one of the interesting findings from this study, which we haven't seen really in our national level studies, is the idea that if there was an EU law, it would require, it could have the impact of raising the standard where companies are struggling to change systemic issues on their own. So we'll hopefully get to that as well shortly. The regulatory review, again, very important to understand due diligence not as a tick box, not as a paperwork, not as a certification, but as a legal standard of care. And so we looked at that. It is already being used in this context in various other ways in civil law, also in statutory labor remedies, etc. So due diligence as a standard of care, something that you have to meet, and then you can also defend yourself in court by showing that you have met the standard of care. We've looked at the developments in due diligence from the UNGPs through the OECD guidelines, and then various also developments currently in mandatory due diligence, in mandatory human rights diligence in some member states. The 12 country reports focus on Belgium, Denmark, the Netherlands, Finland, France, Germany, Ireland, Italy, Poland, Spain, Sweden, and the UK. And those are in the annexures. The full reports are in the annexures, but they were summarized by Professor Arden Corkadale, who I believe is on this call for our study. And then we have, this is the last slide, just a few sort of key observations. Again, the importance of understanding this as a standard of care, the risks that there are in treating this as a blanket tick box exercise, which will be counterproductive to the whole point of it, but also very, very burdensome. And so we understand it in the way that the UNGPs understand it, and that is also what stakeholders said. It has to be built upon that concept of human rights due diligence, context specific, etc. The leverage of the individual company versus the collective EU standards. So the idea that there are these systemic issues, modern slavery, child labor, that individual companies struggle, even the leaders struggle to fix by themselves, even with the exercise of leverage and everything. So the idea that if there was an EU standard, it might incentivize action, not just from the others in the same sector, but also from others in other sectors who work in the same region and face the same issues. So there is that cross-sectoral power that the EU can bring. And then the idea that it again should be part of a smart mix. So there was acknowledgement, even though that fell outside of the scope of our study, but it should fit in with the trade reform and policies, etc. And then lastly, the interaction of this standard and the complementarity with existing regulatory requirements. So, for example, the EU Non-Financial Reporting Directive already exists. It's fairly new. So stakeholders did mention that, but the idea that this would fit in with that, because currently there's not always a lot of clarity about what is material, and then if there's a legal standard, that would automatically bring something into the center of the materiality question, where it's currently maybe a bit more borderline. Again, same with directors' duties and materiality there, to really center the law and what is required and clarify the legal standard also in that sense. And then thirdly, industry standards. Many industry standards are very technical, very developed, very well established. They obviously have taken into account the specificities of the industry already. And so the way it has worked in other areas of law, where there's a due diligence or a standard of care, the industry standard would be a sort of a benchmark. So if there was a challenge to a company's due diligence and the company has let's say never participated in any of the industry standards and never actually met any of the industry standards, that would raise some question marks. So, and the flip side of that again is that if there is an industry standard and there's been a lot of work done in accordance to it, it might not be that reasonable to expect the company to go further than that. But that's not necessarily, I mean, that's not necessarily to say that there should be a certification or anything based on industry standards. So I think I'll stop there. I don't want to go over time. So Colleen, I'll hand over back to you.
Thank you so much, Lise. That's so insightful, and I wish that we had a lot more time to be able to explore this. I know certainly for those people listening, in our sort of preparatory discussion, we had a really long and interesting conversation around a lot more of these aspects. So really, from my point of view, and I'm glad to see that I'm back again, is that I just wanted to perhaps draw together some of what's been said through Lise and Phil, but particularly with a focus on how business might start thinking about addressing these issues and making some of the challenges that we're seeing practical and how they deal with it. So we can't, of course, talk about, what is going on without some kind of reference to COVID. And I see that I'm off the screen again, sorry. Phil was the one that had mentioned that, of course, we're in a converging crisis. And what we've seen through COVID is, of course, highlighting these incredible discrepancies between the haves, the have-nots, the inequalities, and particularly around how companies are organizing their supply chains and managing the negative impacts that they might have either around human rights or environmental issues. And just then to say that, we see that mandatory due diligence is definitely an issue as we've seen, whose time has come. And it's interesting that Lise pulled out from what she was saying in her report, is that it was recognized even by those organizations that were surveyed that the voluntary guidelines and principles are just failing. They are not enough to be able to create a level playing field and for business to really be tackling some of the real issues around environmental issues and human rights problems. And as you saw, Phil had already highlighted that there were a number of increases in national legislation addressing these issues. So sorry, technology is proving a bit of a problem today. Now my mouse is not working. But this is just a snapshot of some of the initiatives in a timeline over 9 years of national legislation that is requiring business to really be providing disclosure on the steps they're taking to address human rights issues or issues around modern slavery in their supply chain. It's very focused on the human rights aspect, and I think what we shouldn't lose sight of is that there is a raft of legislation that's also being developed, due diligence legislation, to address environmental issues and issues specifically around climate change and conflict minerals and timber regulation. This is a really useful slide just depicting in Europe the countries that have been taking steps to address supply chain issues, both environment and again in relation to human rights. And what I think is going to be quite interesting is to see what will come out of the EU with their consultation to develop a standard due diligence legislation, and then how the different countries will deal with the bills or the draft acts or some of the acts that are already there to either to be aligned with any form of EU legislation. And of course, it also leaves open the question of where what the UK might do, because by that stage we will have exited Europe, and whether or not they decide to adopt the same principles. But I think the thing that I was most that I wanted to talk about today the most was actually this question of what is the law saying? What are the trends that we're seeing in the law and the legislation? And I think one of the key things to remember is that reporting on actions is not the same as actually carrying out due diligence. There is a distinction between how you do things and then how you report on them. And what we've seen too often is that there has been just blatant reporting without necessarily having processes underpinning the policies that are put out publicly or that have been shared. And I think there's no better example than perhaps what we've seen perhaps what happened with Boohoo, that there seems to have been a lot said in some of their policies, but perhaps not such a follow-up in operationally managing their risk. And a really practical example around this is what has been happening around the French Vigilance Act. And the requirement in that Vigilance Act or the legislation is that companies have to ensure that they take measures to identify and prevent the risks of human rights and environmental violations caused by their activities and those of their subsidiaries. So going beyond just their own activities, but also how they're managing this in their subsidiaries. And the measures have to be published in a plan, but they have to be effectively implemented. And what is really critical about this is to see that the actions that are being brought now against Total, as an example, by groups of NGOs, is that they are challenging the statements that are being made, where those statements are alluding to specific global issues like climate change being a global risk to the planet. And what they are saying is that is not enough. Total need to be talking about how that global risk actually has been identified as a risk specifically in their own business and their supply chains, and how they are managing those specific risks. And that's very much a trend that's coming through, not only in the courts, but also in the national contact points. When you look at, for example, a case that was raised against FIFA, and when the national contact point investigated it and actually and made a judgment or made a judgment on it, what they were saying is that actually, again, FIFA didn't have any policies that were specific. There were generic policies, or there were no policies. And so it's going down into that specific understanding of risks to the business itself and how to actually tackle them specifically. And then, how does this translate for business? What is it that we really should be thinking of if you are a business that might be facing mandatory due diligence and wondering what you do? And I think what Phil had mentioned earlier on is really critical, was that we should be looking at a change in culture. It's critical that a corporate culture is actually embodied, where there is a corporate governance structure in place, where there is a leader, as Phil said, not just a team that is doing something, but a leader, and specifically a director who is managing and taking responsibility for the issues across environment and human rights issues. And that in itself should lend itself to buy-in from management, to have the executive council, the key managers, understanding what it is that is required of them in their own job functions and what they should be doing to try and build due diligence frameworks that are effective, and ensuring that there's proper monitoring in place. And I think that what is really critical around this is how businesses start addressing the silo mentality. Because we have seen a lot come through around environment, climate change protection, and we're seeing more come through around human rights. And we are seeing a movement towards discussions around ESG to integrate these things. But in reality, there needs to be a lot more thinking about how you address the silo mentality. And we saw this 2 years ago. I worked with IEMA to publish a guide on addressing compliance for both environmental and human rights issues in business. And we ran a number of stakeholder workshops, and what we saw across the board was that, you know, a lot of organizations are aware of what they need to do, but there is still not a real knitting on together of teams and thoughts on how they're going to manage this. And I think if we are going to see legislation that is going to address both environment and human rights issues, there will have to be some real thinking around how the business model needs to be adapted to try and pick up on these issues. And I know there's going to have to be some fundamental shifting in how you think, because there's different ways of looking at risk management. Environmental risk is measured and managed in a different way to human rights risk, where there has to be a completely different thought process around how you address the potential impacts to the communities that you are dealing with, be that your employees, your supply chain, your indirect workers, your contractors. And I think that there are some really key steps that can be taken. I mean, mapping your supply chains. I think a lot of people talk about it, write about it, but actually when you go back to where you're at as a business, a key question to ask is, have you mapped your supply chain? Do you really understand where your impacts are, both on an environmental and a human rights side of things? Have you considered what relevant guidance there is? There's more and more information coming out at different levels, government levels, NGOs, business to business, trade associations, some trade associations putting out very good guidance to help business around thinking around these structures and what they're doing. Creating cross-disciplinary groups in a company, I think that's really key, is that to have functions across the company being able to address these things, from procurement to legal to marketing to operations management, to having the boards and on board, and really how you integrate these things. And I've seen a growth in sort of cross-disciplinary groups, things like ethics and compliance groups, where these things and these ideas are brought together. And I think it goes without saying, but I've not ever been surprised at how many organizations still haven't undertaken a real benchmark of where they are. So understanding what your current policies say, or if you don't have the policies, to map what policies you might need. And then critically, once you've looked and seen what your policies are, what are the procedures that are being put in place to underpin those policies? And then really just my final slide before we go into accepting questions is looking ahead. Where are we going to be? And I think what is really critical is that we're going to hopefully start achieving a level playing field, where a lot of organizations who perhaps have been doing far more than some of their competitors in this field have borne the cost of that, are saying, actually, we need legislation to level out this playing field so that it becomes fairer in the markets that they deal in. I certainly think that we're going to be seeing more benchmarks around disclosures to even and standardized data, so that it becomes easier to measure impact and to measure the differences between performance in organizations. That's been a long time coming. I think 15 years I've been hearing people talk about benchmarks that we need, data that we need, and hopefully we now are entering to the era that will happen. Certainly more emphasis on the S in ESG. We're seeing increased shareholder pressure, and that's what's marked about that too, is suddenly starting to see shareholder resolutions around human rights issues, whereas we've started getting used to seeing shareholder resolutions around climate change. And finally, probably an increase in parent company liability, as more vulnerable people, or people who have been negatively impacted by failures to companies to really understand and manage their impacts in a responsible manner, are looking to the court for some kind of help and compensation. So I'm going to stop just there. I see maybe that I froze again, but I'm going to stop there. I'm going to thank Lise and Phil again, and we've got at least 5 minutes, 10 minutes now to allow for questions. So if you want to just go into the question and answer or the chat function, I'll try and pick up some questions from you. So just waiting to see what's coming through. And perhaps while we wait, I can just put a question to Phil and Lise myself. And the question really is, you know, what do you see as being critical in a need for addressing this point around culture and responsibility within companies to really start making a difference?
Oh, would you like to go first?
Yeah, that's fine. Thanks. Well, I think that issue with culture, we all know. You know, I've worked as I think you reported earlier, I worked for years at Oxfam, a very large organisation. So shifting organisations, culture is not a simple or quick task. And that's always a challenge, but shifting the culture is probably the most important role that leaders have in their organizations, because it's the culture that defines whether you are essentially fit for the future or not. And therefore I would argue that, you know, the leaders in large and medium-sized companies that are likely to be covered by the increased levels of regulation now need to be anticipating this legislation in order to start shifting their cultures substantially towards internalizing the social and environmental costs that they have traditionally had a culture of externalizing, precisely because in many ways, and I say this cautiously but with a lot of evidence, you know, it's legal counsel that has said repeatedly, you know what, you can get away with this. Your fiduciary duty is to maximize the short-term return to shareholders, so get on with it. Even when we've been raising with the company, you know, we take up 650 allegations of abuse a year. A lot of the sustainability and human rights, ethical purchasing departments come to us and they explain that, you know, they're very keen to make change happen, but they can't do it often because the inertia in the company, the culture in the company, and legal counsel is saying in the same room when they're called in to deal with the allegation, essentially, you can ignore this because we run no significant legal risk attached to this allegation. That is about to change, I hope, because I believe that capitalism, global markets will be far better served. This is the acupuncture point that has been defined by legislators, parliamentarians, and by investors and companies as the means by which, rather than getting a sledgehammer to crack a nut, they can insert a needle, you know, that acupuncture effect, to make that significant shift about a substantive change in the calculus of legal risk inside company boardrooms. And it's those company boardrooms that will eventually change that culture. So I think good leaders now will be making those decisions to fundamentally shift the culture inside the organization.
Thank you. That's really insightful. Lise, did you want to add something to it? And then I've got a question that's come through.
I can just confirm that, you know, what Phil was saying is, at least in the interviews that we've done for this study, but also previous studies, the importance of the law in really making that internal change. And, you know, we have good quotes, even from previous studies, where they were saying you just really need that push, you know, from the law. And then suddenly the matter gets attention and takes seriously. Even some companies that have told us that they're not even, for example, the Modern Slavery Act, the UK Modern Slavery Act, they're not even subject to it. They're based in other jurisdictions. But when it came in, they suddenly realized, and there's a lot to say for that, I think, internally. Some of the examples also that we used in some of the interviewees mentioned is the example of environmental laws that have been in place, you know, for a bit of a longer time, and they have become a lot more integrated in terms of corporate culture. Another example is the Norwegian rules on women on the board. And that was one of the examples that one of the interviewees mentioned in terms of, oh, there was an overnight sort of fix almost, and it's really what the law did there, which it was voluntary for decades, and then suddenly overnight when the law came in, so hopefully there will be a change. But like Phil says, it takes time to change a corporate culture. But the companies that we've interviewed that have that tone from the top and that have that leadership say that it is so much easier to do that.
Absolutely.
Yeah.
I think that's absolutely right. So thank you both for those insights. We have a question that's come through to both of you saying, the presentation suggests that certifications are not a solution. If a business has invested time and money to get their supply chains, for example, fair trade certified, what aspects of the mandatory social due diligence is missing in your opinion? Who'd like to go first? Lise, are you saying yes?
Maybe I should go because I was the one who said that. This is a really interesting and important point. The certification method in and of itself, the reason I said that is because often due diligence is understood as a sort of piece of paperwork. It's often like that. You get a due diligence done, and then you've got a certificate, and then that exempts you from liability. That's not how the standard of care works, because with due diligence as a standard of care in other areas of case law, you might have the certification, but if there are still risks that you should have known about, that you should have addressed, the paper will not help you. So then and even having a policy or a process will not help you unless it was actually implemented. So the court will go beyond that. I mean, this is obviously the way, if it works the way we thought it would work, but it would go beyond that and say, well, what happened on the day? What happened on the ground? What happens on a daily basis? What is really happening in this company? The facts are always extremely important. It's always going to be a factual inquiry with this kind of thing. So there, a certification might be a tool, and I think it ties in with also the understanding and the importance of industry standards. So a company that has done a lot of work to get the certifications, to get the fair trade, for example, is a really good one. And there's a lot of work going into those fair trade prices. And we even discussed, I think we even do have a case study about the fair trade price in our study, where we're saying, well, we're not proposing that there should be a law that says fair trade price now becomes the legal price. That's, we're not trying to interfere with the market that way, and we don't think the law should be that prescriptive. But obviously, if this is applied in the right way, the industry standard and the fair trade price and whatever else certification will be extremely important on the facts. So if you come to the court and you say, well, we've been paying the fair trade, we've been looking into the fair trade, we're reaching it, we're trying to reach it, this is the work we're doing toward reaching that. That's due diligence. That's what the court would presumably like to see. So it's definitely one of the ways in which you demonstrate your actions. But the reason I said that is that we should guard against understanding this from a legal perspective as an exemption type clause, because that's something that companies don't want. It has to remain flexible, because on the other hand, it might also be possible to show that you have done your due diligence without having that certification. But you have other processes in place and you think you've got lower risks there, etc. So it's always going to be a lot more fluid than that. I suppose, I don't know if that's clear, but so I'm not ruling out certifications or industry standards at all. In fact, I think they're really important.
Thank you, Lise. I don't know, Phil, if you want to add something on that. We are actually out of time, and we've got a load of other questions. So perhaps I can share them with the panelists, and we can, try and answer some of these. Or I know, Lise, somebody asked for the link to your report, and we'll. Oh, there we go. You've actually put it on there. That's lovely. Thank you. So apologies for some of the tech issues, but a huge thank you to all of you that took the time to join us today. And a massive thank you to Phil and Lise for their erudite and very helpful, insightful presentations today. I hope you've enjoyed it. Look out, we've got some more interesting webinars with some great thinkers coming on, and wishing you all a really good day. Thank you very much. Thank you. Thank you both. Bye-bye.